Hello everyone. Today I would like to talk about a relatively complex subject under the immigration law. I will do my best to make it as easy to comprehend as possible. The subject that I'm going to talk about is PRRA, or Pre-Removal Risk Assessment. So what happens is that sometimes when people are inside Canada for several reasons, for example, non-compliance with the act, being inadmissible to Canada due to criminality, security reasons, or misrepresentation or other reasons, they receive a removal order from Canada. I have another video about removal orders that you may watch up here, but in general, when you receive a removal order, that removal order could become enforceable. When a removal order becomes enforceable, you have to leave Canada. However, the government of Canada wants to make sure when they remove you from Canada, you can go back to a safe place. You don't go to another country that your life is in danger. That's why there is a process called PRRA that they want to go through that process to see if it is safe to let you go. However, it is up to you to make that request. So they give you this opportunity, but if you don't make that request, they will remove you anyways. Generally speaking, you may request a PRRA if you have received an enforceable removal order with a notice from CBSA that notice says that you are eligible to apply for a pre-removal risk assessment. The only exception that I can think of right now is somebody who receives a removal order at a port of entry, and at that moment on the spot the person makes a request. But in other cases, I would say that you already received that notice from CBSA. The question is that who is eligible for pre-removal risk assessment? It's very difficult to make a clear list, but I do my best. So these are some conditions that, based on that, it looks like that you're eligible to make a request for a PRRA. So you have not sought protection in the past, you have a failed refugee claim, or you are not eligible to file for asylum in the first place, some conditions apply. You have received a notification of PRRA clearly from the immigration authorities or from CBSA. You have received a removal order because of security, human rights violations, serious criminality or organized criminality, or you are filing for protection at a port of entry. You definitely need to consult with a professional to make sure if you are eligible to apply for pre-removal risk assessment. The next question is that who is not eligible for a PRRA? So these are the people who are not eligible for PRRA. If you have received an extradition order, so a court in Canada has decided to extradite you to be prosecuted in another country, then unfortunately you are not eligible for a pre-removal risk assessment. Also, if there is a 12-month ban for you to apply for PRRA, then you may not apply for PRRA. If you are coming from the United States and the agreement between Canada and United States called Third Safe Country applies to you, then unfortunately you cannot use PRRA to protect yourself against going back to the United States. If your removal order is not enforceable, you may not apply for a PRRA. And also, if you have been identified as a convention refugee in another country, then you may not apply for PRRA. Again, This is a simplified list, but at least if you combine who is eligible and who is not eligible answers to those questions, then you could get if you are eligible or not. But I highly recommend that you consult with a professional. So you may ask, what is the 12-month ban anyways? So if you apply for refugee to Canada and you receive a negative decision by IRB, whether it is because of refusal of your application, abandonment, withdrawals, any of those negative aspects of application, or if you apply for a PRRA and you receive a refusal by IRCC, in those situations there will be a 12-month ban on you. It means that within the next 12 months you may not apply for PRRA. However, there are some exceptions for certain countries. There is a list on IRCC website. I have the link down below. You can view that and see if those exceptional situations apply to you. What is the application process? So there is a form, obviously. You need to prepare your identification documents. There is no processing fee. You prepare all the application, all the documents, supporting documents that shows that why you deserve a pre-removal risk assessment, and then you submit this application. At the moment, most of the application will go to an office in Vancouver, the Humanitarian Migration Office in Vancouver. They review the application and they decide whether to approve it, refuse it. In some cases, they might run a PRRA hearing that you need to attend. It's an oral hearing, or sometimes they may request extra documents. And then if they approve your application, then you become a protected person. If they refuse your application, then your removal order becomes enforceable. Also, you need to keep in mind that when you receive notification of PRRA, you only have 15 days to file for a PRRA. And after filing for PRRA, you have another 15 days to submit any supplementary documents. So can you work in Canada while you have applied for a PRRA? So if you have already a valid work permit, you may continue work. If you don't, and this is the first time that you are filing for PRRA, then you can include an application form for working in Canada with your PRRA application, and if they approve it, then you may work in Canada. However, keep in mind, if you do not have a valid work permit, or if this is your second time or third time that you're applying for PRRA, in those situations, unfortunately, you are not eligible to work in Canada. Also, you may not apply for a work permit if you submit your PRRA application after the deadline. Can you use free healthcare in Canada while you are applying for PRRA? The answer depends on your previous situation. For example, if you are a failed refugee applicant, you may still have access to IFHP, which is Interim Federal Healthcare Program, and you may use that. So what happens if the government refuses your PRRA? If the application is being refused, then what you can do is that, first of all, you can request for reconsideration. Also, by default, you have 15 days to file for judicial review. Otherwise, if you don't challenge that decision, your removal order becomes enforceable and you have to leave Canada. What happens if they approve your PRRA? Of course, if they approve your PRRA, you become a protected person. As a protected person, you normally are eligible to apply for permanent residency to Canada. However, under certain situations, for example, if your removal was based on serious criminality, this eligibility is not there and you only become a protected person. Thank you very much for watching this video. Please make sure to follow our YouTube channel, subscribe to it, share these videos with your friends and family members or whoever is interested in immigration to Canada. And of course, enable notification to make sure that you are notified about our newest videos. See you soon.